Federal Educational Rights and Privacy Act, otherwise known by the ominous acronym of FERPA. FERPA is also known as the Buckley Amendment, as its principal sponsor was Senator James Buckley of New York. FERPA was established in 1974, and it applies to all schools that receive federal funds. It gives certain rights to parents and protects their privacy. The parental rights under FERPA consist of the right to review their child's education file. Parents also have the right to request records be corrected if they believe they are inaccurate or misleading. Parents also have the right to a formal hearing if the school refuses to amend the record. If they should lose that hearing, parents have a right to place a statement in the education file regarding their contest to the information. These rights are extended to non-custodial parents as well and eligible students. An eligible student is a student who has reached their 18th birthday. All of the parental rights afforded to parents are then transferred to the student. The student is then referred to as the eligible student. FERPA distinguishes between two types of information: the education information and directory information. Directory information is information that could be published in a team roster or a school directory unless parents otherwise object. The only types of information are listed on this slide. Education information consists of almost anything else that would be in an education file: records, files, documents, information directly related to a student, information maintained by the school or a person acting on behalf of that school. Education information should only be released with a signed parental or an eligible student consent, unless it is released to teachers, counselors, or administrators who have a legitimate educational interest in that child. Schools have their own rights and responsibilities as well. Schools first must provide annual notification to parents regarding their rights. They must also provide expedient due process, which refers to if a parent should have a complaint about inaccurate records within an education file, the school must respond within 10 days or less, but no more than 45 days. If there is still no resolution, there must be a hearing within 10 days. Schools are also responsible to obtain written consent from parents or eligible students in order to release records. Schools are also tasked with maintaining secure records. They usually must be locked away from routine information. Schools may release records to other schools. They may also release records to personnel with a legitimate educational interest in the child. Schools may also charge for copies. FERPA relates to school psychologists in a little bit of a different way. FERPA relates to school psychologists. FERPA states that if a child has been labeled as mentally or otherwise retarded and put in a special class or school, parents would be able to review materials in the record which led to this institutional decision to see whether these materials contain inaccurate or erroneous evaluations about their child. However, parents are allowed to access records such as protocols, but they may not be issued a copy. Sometimes they're issued a copy. It gets very gray in this issue. There's been case law going back and forth. Psychological tests are protected by copyright restrictions, so copying is generally not allowed, but then under the fair use doctrine, it may be allowed if it contains identifying information directly to that student. But non-identifying information has consistently been denied to be copied and presented to parents, such as testing manuals and testing materials, as that would be a violation of the test publishing's copyright. As school psychologists also have a role as counselors, they are not required to share information with parents, as this would breach confidentiality issues between the student and the counselor and could damage that relationship. Counselor personal files do not fall under FERPA. Counselors are only required to break confidentiality if an imminent and viable threat is present or they are court ordered to do so. And here are the references used for this presentation. Thank you.